I'm Drew Stevenson. This is a video from my administrative law class. And here I'm going to be talking about the Freedom of Information Act and Exemption 2 to FOIA. This relates to internal personnel rules and practices. So let's dive in. The Freedom of Information Act requires federal agencies to turn over information and documents upon request, subject to some pretty big exceptions. There are 9 statutory exemptions in 5 U.S.C. Section 552, and here I'm talking about the second one. So it basically says that this section, that is FOIA disclosure requirements, does not apply to matters that are, quote, related solely to the internal personnel rules and practices of an agency. To give an example of FOIA Exemption 2, we actually had a U.S. Supreme Court case about it in 2011 that's interesting or worth talking about, that helped change the law in this area about Exemption 2. So this is Milner versus Department of Navy. In the current edition of the casebook I use for my course, this is mentioned in the notes in the FOIA chapter. So the Supreme Court held that Exemption 2 has a pretty narrow scope. It applies only matters related to hiring and firing, work rules and discipline, compensation and benefits for government employees, things like lunch hours and parking, and does not include, for example, the FOIA request in this case was information about the storage of explosives at a Navy testing ground for offshore munitions. That's what someone had asked for, and you might think that the Department of Navy would have just invoked Exemption 1, but instead they had invoked Exemption 2, saying that it was personnel records where their personnel were directed to stack and store explosives and munitions at this munitions base. Before the Milner case, a lot of the lower courts had been applying Exemption 2 very broadly to include almost everything that involved agency employees and their tasks, or that was outlined in agency policy manuals and so forth. And any documents that were predominantly internal could somehow be fit under FOIA Exemption 2. Well, the judiciary's expansive view of FOIA Exemption 2 before 2011 had signaled to the agencies that this was a get-out-of-FOIA free card, and so they were invoking Exemption 2 for basically everything that they didn't want to disclose, even when there were other exemptions that seemed more applicable because they thought that Exemption 2 was safer or more strategic. In fact, prior to Milner versus the Department of Navy, the courts had started using this moniker low 2 to refer to traditional personnel matters, and then high 2 to refer to any other internal documents whose disclosure might facilitate circumvention of agency regulations. But all this talk about high 2 and low 2 under FOIA Exemption 2 is a thing of the past. The Supreme Court rejected this line of cases in Milner versus the Department of Navy in 2011 and held that Exemption 2 should apply narrowly to traditional personnel matters. And that concludes our quick overview of FOIA Exemption 2. Thanks for watching.